tonight's topic is all about separation and divorce and what you need to know if you're going through this situation. So Andrew, before the break, we were talking about how to pick the right lawyer. If you can finish off that point, after you do pick your lawyer, what happens then?
Well, it depends on your case. Ideally, your lawyer will write a letter to the other party if they don't have a lawyer, saying we'd like to negotiate, we'd like to resolve the dispute, saying what the issues are, and suggesting how we can move forward. The problems happen when somebody ignores you, because if somebody ignores you, how do you get their attention? And usually that, regrettably, means you have to start a court action, because someone can get my letter and throw it in the garbage and say, I don't really care what Andrew Feldstein has to say. But if I start a court action and I take them to court, now they have to deal with me. And hopefully that will still get the ball rolling to negotiate a resolution.
Okay, so let's talk about the two separate scenarios, because I know that you can figure out sort of your separation process privately, or like you're referring to the courts. So what if you have decided to separate with your spouse, but you two are on somewhat mutual good terms? Let's talk about that scenario. They come to you and they say, Andrew, you know, we've both decided to go our separate ways, but we want to settle privately. What happens in that case?
Well, people need to have their own lawyer. So two people can't come in and hire one lawyer, because my loyalty can only be to my client. It can't be to both sides. So each side will have their own lawyer.
It doesn't matter if they have a mutual decision, separate lawyers.
Separate lawyers, no matter what. They can each send directions to their client, to the lawyer in a meeting or by email, telling us the nature of the agreement that they want. And as long as they've provided financial disclosure and the deal seems reasonable, we'll do it. What do I mean by that? They have to give their tax returns. They have to give a list of their assets and liabilities, preferably in a sworn statement. The reason that's the case is the family law says you must give financial disclosure. You can't waive it. You can't say, I don't want it. And there's a decision from the Ontario Court of Appeal that is very strong on that point that says you can't waive it. So we're very concerned that our clients will always give it, because that's important for a deal. And then if the clients instruct us that they want to do a deal, the deal has to be reasonable. What do I mean by that? If I have somebody come into my office who's been married for 20 years, has been a stay-at-home parent for the last 20 years, they have no income, and they say, the kids are staying with me, I don't want any spousal support, and I don't want any of the assets.
Okay.
That's a pretty horrible deal. I'm not going to put my name to that. I'm not going to be a party to that kind of deal. But if they come in and they have a deal that makes sense and is reasonable, that's a great way to save legal fees, because at the end of the day, what's going to happen, instead of paying me to negotiate, they're just paying my office to draft and make sure that that reflects their wishes. And that, by far and away, is the best result for people if they're able to achieve that.
So, you know, through your years of experience, is it better if a couple does settle privately and on their own terms and not take it to court? It's
always better. Court creates conflict, stress, and it costs a lot of money. It's something you don't want to do. It's realistically, it's the last resort. And the kids are the ones who will also pay a price if you have kids, because they're going to see mom and dad angry and stressed. And when you go to court and there's negative statements made about the other one's parenting skills, or they're hiding money, or they did all sorts of things, all of that will resonate for a long time, that it will take those people to forgive. And like I said before, kids are going to be stressed even if they're adults.
So I was doing a little bit reading on this topic, and I read that in this sort of separation and divorce proceedings, there's a separation agreement. What is that, if you can explain to viewers?
A separation agreement is the document that deals with basically everything other than the divorce. What do I mean? That can deal with your custody, your access, all your parenting rights. It can deal with how much child support you're paying, how much spousal support, what amount of money you're going to pay for the property settlement, who gets the houses, the household. It deals with everything. The only thing it won't deal with is the divorce, because in order to get divorced, you have to go to court. But if you have a separation agreement, and there's reasonable arrangements made for child support, which can be an impediment to getting your divorce, the court will grant the divorce, and nobody needs to physically go to court. It's all done by lawyers filing paperwork.
So Andrew, that separation agreement, do you advise couples to take notes, have a point form note before they come and see you, and then you put together the separation agreement? Is that done through the lawyers?
It works in different ways. Some clients will come in and they have a very direct idea of where they want their settlement. And if it's reasonable, as I said, we'll execute on that. Other clients will come in and they'll want our opinion as to what we think is reasonable, and we educate them as to what we think is reasonable, and then they sit down either with a mediator or they sit down with their spouse, and they try and work out a deal at first instance on their own. And a lot of people successfully do that. And that will save money because then they come back and tell us the deal they made.
Now, we have some books here laid on the table for this segment. Can we just quickly talk about this book? Because I was briefly just browsing through it, and it's a good handout. It's a good sort of summary about family law in Ontario.
It's what you should know about family law, and it's a free book that anyone can pick up at any courthouse in the province of Ontario. At every courthouse that has a family court, there's something called the Family Law Information Center, and they can attend the Family Law Information Center and they can pick this book up, which is what you should know about family law in Ontario.
I mean, that's the industry you've been in for 20 years.
That's right.
I mean, you've seen it all. You've seen it all. And I mean, do you agree that it is an emotional process for families and for couples, separation and divorce?
It's probably in my view, the most emotional event a family will have. There can be nothing more traumatic than seeing, will I see my children? How often will I see my children? Will I have enough money that I can live in a decent home? What can I afford? All of those things go to the core of who and what we are. And when you're going through this, you don't feel that you have any safety or security to know where you're going to be or what you're going to be like after it's all over.
Right. So, you know, we talked about the scenario, you know, settling privately, trial. That's a whole different landscape, right?
Understand, trial is the absolute worst. About 1% of cases ever get to trial. A lot of cases will go to court, and at court we are working on trying to get settlements. So part of the family court process is you have a case conference and a settlement conference to try and settle your cases and avoid a trial.
So like you said, more complicated. I didn't know that, 1%. 1%.
1%.
Okay.
Very few trials.
So when we come back from break, we'll talk more about, I guess, the trial scenario and more about separation and divorce. Stay tuned.